Good evening, sir.
Yes, very good evening, Riddhi. Riddhi, my first question to you is an extended question which is being asked by Purva ma'am. And the question is that if a concerned police officer has issued a notice of appearance to the accused under 41 capital A of CRPC and the accused does not make his presence ensured, what kind of penal provisions can be imposed against such accused person because of this particular violation?
So, warrants of his presence can be issued against the person.
Okay. And because of this default, that is the non-appearance before the authorities, do any provision of the IPC is also attracted?
I, yes, sir. I did read about the provision, but I'm not able to recall the particular section.
Okay. Okay.
100.
Uh, anyhow, Riddhi, as you are from Kangra of
Yes, sir.
Himachal Pradesh, you just tell me that what is the old name of district Kangra?
Old name of district Kangra. So I think, sir, it was Guler.
Are you sure?
I'm
गुलेर
not
की
sure,
रियासत
but
तो अलग है. गुलेर की रियासत तो अलग है. What is the name
okay,
of
sir.
Kangra, old Kangra?
No, sir. Sir, that I
Not
don't.
able to. Okay. Okay. Vidhi, let us say that there is a dying declaration of a concerned victim. Now he is a deceased, and that declaration is being recorded by one judicial magistrate. Okay. Now, that magistrate had recorded the statement immediately when the event has occurred. Now, after a few days, like 4 or 5 days after that, the statement of the same victim is required to be recorded under 164 clause number 5 of the CRPC. Now we have two statements that one is being recorded immediately the moment the event had happened after few hours, and one statement is recorded after few days, that is under 164 clause number 5, and thereafter the victim dies. Okay. Now, which particular statement will be considered to be the dying declaration over which the trial court is going to rely?
The statement recorded under section 164, the last statement given by the deceased person will be considered as his dying declaration.
And what other factors, being a trial court, you will be looking for that? Do there will be other factors, like because there are two declarations of the same person given before two magistrates, both the magistrates are having the same kind of a competency because both are judicial magistrates. So how you are superseding one over the other? How you are giving preference to the second declaration over the first declaration?
So the dying declaration is generally given at the very last moment of the deceased person. So the statement recorded under before 164, the statement recorded by the first magistrate will, if the person did not die at that time, would have been considered as a statement under 164. But the second statement recorded by the judicial magistrate under section 164 before the person died will be considered as a dying declaration, as it had been very near to the death of the person, and all the facts would be stated as he has already stated in his prior statement.
Okay. So let us see an extended point on this, that in the first statement, that victim has stated that her husband is responsible for the injuries which are being caused to that lady. That victim is a lady. And in the statement given to the magistrate, that is the first statement which is being given. She is saying that the reason of these injuries is her husband. And in the subsequent statement, she is saying that no, my husband is not anyhow related with this particular injury. Now, what you will be doing?
Sorry, sir, we'll have to weigh and sift all the materials available with us in first statement or second statement, and of the other witnesses also available. That if one of the statements given by the deceased is concocted or not, we'll corroborate the statement in accordance with the other evidences presented before the court.
Okay. So, Riddhi, my next question to you is that as once you get selected as a judicial officer, you will be getting a post of judicial magistrate second class. Okay. So, let us assume that you are a judicial magistrate second class and there is a person detained by the police authorities and that person is produced before you. There is no other judicial magistrate first class available. So they produce the concerned accused person before you, and you want that this person should be detained in the police custody. So do you have that competency to order?
Yes, sir.
Are you sure?
Yes, sir.
Judicial magistrate second class is having the power to order police custody. Per se, do you are having such powers?
Yes, sir.
Okay. My next question is, Riddhi, that what do you understand by petty offences?
So, petty offences are trivial offences that does punishment is in case of fine is not more than 1,000 rupees, but these does not include the motor vehicle accidents in it.
Okay. Okay. So, Riddhi, let us say that there is an offense which is appearing to be a non-compoundable offense. Okay. So, it means that the compromise in that particular offense is not allowed by the Code of Civil Criminal Procedure. So, by any means, in a non-compoundable offense, any court has having the competency to go for the compounding. Any court in a non-compoundable offense.
No, sir.
And what is your take with respect to the high courts?
So it has been clearly stated in Code of Criminal Procedure that courts can compound those offences only which are specifically mentioned under Section 320. Other than that, no offences can be compounded by the courts.
Okay. So let us say that before the High Court, the proceedings are filed under Section 42 of the CRPC, and the High Court go for the quashing of the investigation and the quashing of the orders and whatever the things have been passed by the court. So what will be the impact of that quashing?
So in relation to the
Like there was a particular case which was a non-compoundable case. But the parties are ready to get into the compromise, but though because of CRPC it is not allowed. The parties went to the Honorable High Court and they are saying that this offense is a non-compoundable offense, but we had entered into a compromise and we need that the proceedings should be quashed. So do the High Court is having any such competency to do so?
yes, sir. Yes, it does have that inherent power to quash the FIR.
Okay, so let us say that there is the offense of rape, which is being there, and during the pendency of the proceedings, the victim, that is a rape victim, and the rape accused, they both are ready to get into the compromise. That is, they are saying that okay, we are going to marry with each other. Okay, and because it is a non-compoundable offense, and they go into the High Court and they want that the proceedings should be quashed. Do the High Court will be doing so?
The High Court will be considering all the facts given, the reasons. The reasons that would be given by the complainant to it, because there has been certain previous episodes that does have this thing that the complainant did say that she'll marry the accused and will compromise the matter or will compound the case. So High Court will be considering all the factors in relation to the statements of the complainant and the accused and other factors relevant in the case according to that.
So is it not something which is a clear-cut violation of the guidelines given by the Honorable Supreme Court in Daksaban versus State of Gujarat?
Sir, I'm sorry, I'm not I did not read the judgment.
Okay, okay, and no issues. Riddhi, my next question to you is that what do you understand by the term functus officio?
Officio. So,
Are you anyhow aware of this statement?
yes, sir. Yes, sir. So I have heard, and I I do understand the term also. It's but I'm not able to narrate the exact wordings.
Oh, no issues, no issues. Riddhi, my next question to you is that with respect to section number 167 of the CRPC, there is a very important judgment that is being decided by the Honorable Supreme Court, that is Anupam J. Kulkarni's judgment. Are you aware of that?
No, sir.
Okay,
I've
so
not.
okay. So, with respect to the ordering of the police custody or police remand, the moment the accused is produced before the magistrate under 167 of the CRPC, what will be the maximum time period for which the person can be detained in the police custody?
So 14 days.
Is it 14 days or 15 days?
14 days.
Practically 14 days or theoretically 14 days?
So theoretically 14 days, practically 14 days.
Are you sure?
Yes, sir.
Riddhi, are you aware of the concept that the court can order protection orders?
Yes, sir.
Under which law these protection orders are being passed?
So under Domestic Violence Act.
Okay. And what kind of protection orders can be there? Any instances of that?
So under Domestic Violence Act, the protection orders are basically that no more violence will be meted to the complainant by the respondents in the domestic premises or in any other residence provided by directed by the court to be provided to the complainant by the respondent.
Okay. Riddhi, my last question to you is that let us say there is a person who is in a police custody. That person makes a statement to the police officers, but that statement is not a confessional statement. But while making that statement, such person discloses certain facts, and on the basis of that disclosure, the discovery is also there. Do that discovery is anyhow relevant, and if relevant, which provision of CRPC as well as of Indian Evidence Act will be coming into picture?
So as per Indian Evidence Act, it will be covered under Section 27, Discovery of Facts. Sir, and under CRPC. So I'm not able to recall the provision under CRPC,
Okay,
but
no
the
issue.
relevancy will be as per 27.
So, are you anyhow aware of Section 162, subsection 2, which is creating a saving clause? Section 162, subsection 2 CRPC?
No, sir.
Okay, chaliye. Anyhow, so I am passing over to Mahendra sir. Mahendra sir,